Welcome. The South African High Court in Pretoria has dismissed an application for leave to appeal in a case involving the family of former Zambian President Dr. Tembeka Ngcukaitobi, who sought to challenge a ruling concerning the burial of the 6th President Dr. Tembeka Ngcukaitobi with costs. The family was contesting a High Court judgment that upheld the Zambian government's right to repatriate the late president's body for a state funeral and burial at Embassy Park in Lusaka, Zambia. Advocate Tembeka Ngcukaitobi of Duma Nokwe Chambers, representing the family, argued that the appeal had a reasonable prospect of success, noting that the Supreme Court might reach a different conclusion. If you recall, Tembeka, the family lawyer, he submitted that South African law should have been applied in the original decision rather than a foreign law. However, Advocate Ben Stoop, the lawyer representing the Zambian government, contended that the application should be dismissed. He stated that the court had correctly interpreted the existence of a contract between the government and the family. In a ruling delivered by three-judge panel comprising acting judge president of the Gauteng division, Pretoria Aubrey Ledwar, the court held that there was no reasonable prospect of success even if it was given to go to a higher court. As the application of the Zambian law, the court considered that the deceased in South Africa for medical reasons. The main parties to the dispute are peregrini. The Kaunda decision is a leading case in Zambia dealing with the state burial. The argument that the deceased was stripped of his benefit is of no moment, the court said. The court said Attorney General of Zambia constituted sufficient expert authority on Zambian law and that precedent established in first President Kaunda's case provided clear legal guidance on state burial in Zambia. The judge further ruled that despite disputes over benefits, Mr. Lungu remained a former head of state. In its conclusion, the bench stated that the matter was highly fact-specific and unlikely to recur in the same form, thus failing to meet the threshold of compelling reasons under the Superior Court Act. The costs have been awarded against the applicant, including fees for two senior counsels. The court, however, has given the family two options to appeal to the Supreme Court or to the Constitutional Court. It's up to them whether they take the lead or it comes to a close. It's a tough outcome for the family, especially that they are going to shoulder both their own legal costs and those of the government's lawyer. It is true that legal battles are never cheap, and this shows how costly pursuing appeals can become. No matter the legal battles, what matters most now is giving the former head of state a dignified farewell in the land he served. Don't forget to subscribe, don't forget to share, and don't forget to like the video. Thank you so much for watching.